Hey y'all, what's good? What is up with everybody? Yes, I'm still having these throat issues. Don't mind me. Let me tell y'all. Did y'all like that bit of nostalgia? Y'all know what song that is? Do y'all know what iconic TV show my little intro song is from? Let me know. Let's see who we got in here. We got my girl Dog Mom. Hey Bloom. Hey Sparky friend. Let's see what you got going on. I have it open in the background, ready for start, studying for exam tomorrow, so maybe may not be too active in chat. You got an exam on Sunday? Are you online school? Good luck. Diet Coke. Hey Bob Kitten. Hey John. Oh man, it is cold where I am. Yes, Manny, that is the theme song for the People's Court back in 1981. Yes. Oh man, how was everybody's day? I am freezing. I'm in the basement and it is cold as what down here. I'm just trying to get the rest of my papers. Give me a second. Y'all know I gotta shuffle through my papers all of the time. So don't mind me. Just hold on a second. Let's see. Oh, that's right. You are in Australia. Okay, well, good luck, boo. Bob Kitten, I'm in Ohio too. It was really nice the first part of the day, and now it is well, it might not be that cold outside, but you know how the basement is always the coldest part of the house, so I'm a little cold. Okay, hold on. I'm coming, y'all. I'm coming. I gotta pull up one more thing, and then I promise I'm gonna start. John, don't start. I'm shuffling these papers like Darrell. Okay, I got my manila envelopes. I got about 10 of them, and I'm just shuffling. Okay, my paper was just right here. Where did my paper go? Who took my paper? All right, who took it? I ain't saying it was y'all, but you know, where is it? Hey, Fama. Oh, are you gonna be able to kick it with us tonight? Hey, Maya, good to see you. Okay, I think we got all we gonna get for right now, and I don't want to delay y'all. Okay, but I spent 2 weeks looking. Hey, Phyllis, nice to see you. Welcome. I spent 2 weeks, y'all, looking for a defense, and guess what? There is none. There is no defense. What you talking about, John? What it do, cuz? Oh, there is no defense, okay? We know there is no defense, right? But what I want to do is go over a few that I thought maybe could have been used. Now, the thing is this, you know how sometimes you may have a good idea and you can't articulate it the way that you need to, but somebody else can explain it and it sounds completely different? I think that's what would have happened had he not fired counsel, right? So they would have been able to get up there and say the right words in order to get the jury to possibly side with them a little bit. If you listen closely to the trial, which I know we all have. Hey Terry, I'm so glad you made a live. How are you? How are you? Oh, Bama, please stay. Please just chime in from here and there, please. I'm gonna get to that in a second. I'm gonna get to that in a second. Hold on. I'm trying to, y'all know, I'm trying to keep up. Okay, listen. If you listen closely to Darrell throughout the trial, he gave several defense strategies that could have worked. It's just that he is not skilled nor trained to be a lawyer, right? So he could not have said it in a way that a lawyer could have to be able to convince a jury, right? So I'm gonna go over a couple of those. Okay. Oh, hey Beverly, we got somebody else from Australia. Look at Sean coming to see little old me. Yes. If you're gonna go through a forensic formulation of the case, oh, maybe next time, Sparky. I'm gonna write that down. I'm gonna write that down. So here we go. So Zarel drove through this parade, right? There was 300 videos of this massacre, right? So he was taken to the hospital. He was interviewed and detained. He was interrogated on day 2. And by that time, they already knew that 5 people died and they had no head count on how many others were injured. So he gets arrested after an unsuccessful interrogation and he goes to first appearance where they go over the charges. They inform him of his constitutional rights. They ask if he's indigent. I'm sorry. And of course he is. And so they have to appoint him a public defender, right? So if it had been me, hey, Kimberly, welcome. Okay, I would have met with him, and the first thing that I would have done was allowed him an opportunity to explain to me in his own words what he thought happened. Before I received any type of evidence, I need for him to explain it to me in his own wording. The reason why is because that will let me know if we had, of course, an insanity plea that we can use, if he had a psychotic break, if he was under the influence at the time. Um, and things like that, right? So he would give me his idea of what happened. After that, I would immediately file a motion for a status hearing and ask for a psych eval. Now, if you remember, the state never called any type of psychiatrists, which are known as expert witnesses, to the stand. And so that would have put a perfect opportunity for the defense to use their own expert witness, a psychiatrist, to lay out the foundation for a possible insanity plea. Now you got to remember this is just preliminary, right? We haven't gone into the evidence. We have not had a trial yet. These are just things that we can possibly use as a defense strategy. So just go with me because I know once I end this, it's going to be a plethora of people in the comments like, no, no, no. Judge Dora already had him evaluated. I know. I am speaking of before he was evaluated. This is after initial meeting with his defense attorney. So just go with it. Okay. Now, the reason why. Hey, Debbie. Hey, Fee. I'm so glad to see y'all. Thank you for coming. Okay. The reason why his not guilty by reason of insanity defense was dismissed, we know part of it was because he was on the phone with someone and they were telling him to use that as a defense. And it is to my understanding that he was getting ready to fudge some information. Now, the reason why is because per the law, if you are going to use an NGRI defense, a personality disorder is not sufficient for using that defense, nor is a drug induced psychosis. And so that is why he threw it out. Okay. He knew per his evaluations that Judge Doro set up that ASPD alone would not have sufficed, right? But for whatever reason, his defense attorneys did not petition the court to get a separate eval based on their research from a different psychiatrist. So that is why I said I would have petitioned the court for a budget to hire another expert witness to see if there was another type of mental defect that you can couple with um, the ASPD and see if that caused him to have temporary psychosis, right? It may be a reach, but hey, we need something. So, we all know what ASPD is, right? It's antisocial personality disorder. And I went through this already. Basically, people with ASPD, they have no conscious of guilt. They are habitual crime. They commit crimes habitually. They show no remorse. They don't feel that they do anything wrong, and so on and so forth. So, that is the whole personality that was displayed throughout the trial. Now, like I said, that's not enough to get him off, but it could have been somebody to say, well, we know he has an extensive history of drug use, the METH use. They can research that and see if maybe, just maybe, that altered his mental status. Also, we know that he had the THC that was purposely or accidentally left on the porch of Daniel Ryder. We don't know if he was under the influence of the THC. We don't know if it was laced with anything that caused him to go into a rage, right? So I wrote that down as a possible defense strategy. Um, I also wrote down that I think the defense tried to use a mistaken identity claim, and that is why they had Darrell cut his hair, he shaved, or whatever. And then, if you remember, Darrell repeatedly made mention that nobody was able to positively identify him because he didn't look like what he looked like when he committed the crime. And the reason why he used that strategy was because that is what his defense team used during the pretrial hearings when they had a hearing with Detective Casey. All right. So that is the reason why he kept questioning the rate of speed. How can you see somebody traveling at this rate of speed? The windows were tinted. The windows. I can't talk. The windows were tinted to what is it high? Because I know it's only a certain percentage that the windows can be tinted, but you couldn't possibly see me because my windows were too dark. How close were you to the vehicle? Can you name an article of clothing that I had on, right? Those were all written down by his defense team, but he wasn't able to come up with questions, okay, to where it can make sense. Y'all following me so far or no? Y'all watching the game too? Okay, so what y'all saying? This a bad time? That's what y'all telling me? They did do 4 evaluations on him, and I don't know which 4 it was. I know one was just saying that he had ASPD, but that was Judge Doro's reasoning because with the NGRI defense, if you know, it's 2 separate trials, and we've seen this with the Taylor Business trial, and I think another one that I watched recently. But you have the guilt or innocent phase, and then you have the actual insanity, legal insanity phase. And so, excuse me, she did her part, but the defense did not do their part. They didn't have any type of evaluations. Those were hers. The defense did not order an evaluation from a psychiatrist. Oh, when? There's nothing. There's nothing. That's why I'm stuck on going through possibly what could have been done and what he tried to do. That's exactly what it is. Okay. So then I thought maybe he could use the malicious accusation. So we know that, he always tried to say that nobody here could identify him and that he is always paranoid due to his personality disorder. And so with malicious accusation, it's a false accusation made by someone with intent to cause damage and without evidence to support it. Does that sound familiar? You didn't file a claim against me. So, what is your intention for testifying? Is it for financial gain? Then he tried to play the race card. You know, he already had a bias and a stereotype against Caucasian, hence the tweets that he had during the George Floyd protests, right? Right? Do that sound familiar? Okay. And see, that alone is not enough for NGRI. So they needed something like bipolar schizophrenia, and that's why he kept yelling that. He knew what was up. Oh, thank you. That's so sweet. Okay. So then I thought maybe he could use a faulty memory defense. And he kept asking, remember what he kept asking um every witness, what they're not telling, what they're not remembering. Did the prosecution lead you to a decision? Remember that? But that won't work because you got to think the time that this happened and the time that the trial started. This was a whole year. And so, yes, people aren't going to remember. And I can't remember the exact term. Maybe Sparky knows. But, sometimes when you're in the middle of trauma, you forget things temporarily and you remember later. Sometimes you forget altogether. I can't remember the technical term for it, but the malicious accusation wasn't going to work. And a faulty memory defense wasn't going to work. Okay. So at this point in time, we don't have anything left. So the defense, the only thing that they can try to do is see if there's a civil rights defense. Was he Mirandized properly? Was the interrogation under 6 hours? Were his basic needs met, such as bathroom, water, food, adequate breaks? How forthright was Darrell during the interrogation? Did he offer information or was he coerced? And did he ask for an attorney at any time? Which they tried to get the case thrown out and suppress that evidence from when he was interviewed at the hospital. Um, so another thing that I remember is Sue Opper said that his competency was never raised, but that wasn't true because with his last pretrial risk assessment before the parade, they did check him for mental competency for that pretrial risk assessment, and it was noted on there that he suffers from severe um mental defects and that he should have been placed in a hospital. So the defense could have used that as a way to say, well, he needed to be evaluated. He wasn't referred to any type of treatment facility or any type of psychiatrist to evaluate him while he was awaiting trial for the incident with Erica. I already talked about the illicit drug use, um, alcohol abuse, and then if I was his defense attorney, I would possibly look into his history of violence and see what it stemmed from. Like we already know, he would get into it mostly with Erica, but and I'm just saying this, as a defense attorney, I'm not saying this right, but, the defense got to defend. So what triggered him to get into these altercations and what was the result afterwards? So did he get into these altercations and then commit a crime after that crime? Were his crimes fueled by abuse from others? Like, did he get into altercations with people and then he would go commit a crime? So I would try to look at the link between those two. I would look at connections of violence and mental health. Um, I would look and see if he has any underlying health conditions that made him lose control of the car. Was his blood sugar low? Does he have epilepsy? Does he have any heart conditions? Did he have a stroke? Does he have narcolepsy? Remember, the defense got to come up with stuff, okay? Um, Let me see. What else did I put on here? For, suppression of evidence, I probably would have tried to see if I can get the, incident with Erica, and I hate to say this, but the incident with Erica suppressed. I would try to get some of that video evidence suppressed, but I will also really like to focus on the getting evidence of him entering the parade and what his behavior was when he entered the parade. The honk and horn defense wouldn't particularly have worked, but to go back to Maya's question, I would have pointed out, the positioning of the barricades, and also if there was enough police to show him how to get off the route, were they actively trying to show him how to get off the route? Um, let me see. And I think that's it. That's the best I could do. That's the best I could do. I would just try to paint a picture that something went wrong. Is he guilty of the crime? Yes. Does he have some type of mental defect? Possibly. And I would just go with whatever evidence I can get from that. And that's all we can do. That's all we can do, y'all. That's as elaborate as I can make it. What y'all think? What y'all got to say about it? Did he didn't he blamed his nephew for what? Running over? Mhm. I thought about that. And now see, I know they drew his blood at the hospital. I have not heard anything about a toxicology report, but that's something that they could have subpoenaed his medical records to get a toxicology report from his blood. And you never know. It could that little Mary Jane that he smoked could have been laced with something. Where am I? I'm so behind. I think that it was inmates that told him that, but I also, like I said, I just read, I'm gonna read the article in a second, that somebody was telling him to just go ahead with the NGRI plea. But I'm gonna read some literature about that in 1 second as soon as I finish this. See, I'm a defense attorney today. We saw him on camera, but it wasn't him. We got to come up with something to help Darrell. Oh. Oh. I know, Sparky, I know, but there's nothing else. There is nothing else. I'm telling you, my search was I exhausted everything. I'm serious. The only thing you can do when you have no defense whatsoever is apologize on behalf of your clients and try to get some type of sympathy from the jury. Now, I don't think that he would have showed out as badly as he did had his attorneys still been with him. And so maybe, just maybe, they would have been able to fight harder on his behalf. But 99% of that was his behavior. If he had a shown some type of remorse, he wouldn't have got off. But hey, remorse is remorse, right? You can make anything you want a defense. There are no rules. The thing with being a part of the defense is that there are no rules on your side. You can say whatever you want. There's no right or wrong. The prosecution is the one that has to prove guilt. The defense has to poke holes in that. So you can absolutely get up and say that my client has a history of alcoholism and drug use. Now, will it go anywhere? Probably not, but you can use it. You can use it. It's people that have used that defense. Taylor Business just did it. Her own father, testified on her behalf and said that had she not been under the influence of METH, that she would not have committed crimes. He also went on to say that had she not married who she married, he wouldn't have influenced her to use drugs and that she would not have committed this crime had she not been a drug user. It didn't work, but that was one of the strategy from the defense. I was supposed to talk about crime of passion. Where did I write that down? Thank you, Bama. I did write down a heat of passion defense. I think I said that. I think I said that I would probably try to look into before I got all of the evidence, I would try to look at his criminal record and see if there's a pattern that would be linked. So his abuse with, females or just different people altogether, what was the end result of that? And so did he become so enraged that he went on to further commit crimes immediately after that? Is there a history there and why? And I would try to link that to some type of mental defect. Listen, the strategy is not going to be perfect, but we just got to try. Yep. See, all of those things would have mattered if he would have put on a nice suit, didn't look dingy, didn't run his mouth, didn't roll his eyes. All of that would have mattered. The jury pays attention to all of that. Yes, they have the evidence, but like I said, it's the defense's job to sway them. You know, you want to sway them from what they see. Yeah, I know what you see is awful. However, it's a tough job. Oh, I didn't know that. Let me see what my boy Bobby Boucher saying. Okay. Fee, I can count on you, okay, to say, "Hell no, that ain't gonna work." Oh, you're right. You're right. You're right. But see, I'm wondering if they could have said that, I'm gonna research like drug use and anger issues and see what I can find. I know y'all about to go off on me, but I gotta try. Okay. I gotta try. But that's what the defense could have did. See, the thing is this: seeing as though he has so much evidence against him already, the defense had to come up with a bunch of strategies, even if they would not have worked. It's so important to come up with many of things, write them down, and just try your best to rationalize it, right? So that while the prosecution is laying out the case, you can just scratch off what you think won't work. Something has to stick. Something has to stick. And like I said, they only needed one count of guilt to be proven for him to go away for life. So we know he's not going to, get out. I'm not saying that. He wasn't going to get off. That's not what this is. This is just possible scenarios that the defense could have used before they were shot down. Okay. Okay. That's right. That's all they can do. That's a good one, nurse. That's a good one. See, he could have. And I'm glad it's a nurse in the chat because what do you think about long-term drug use and behavioral issues? And could you tie that into a defense? I believe that, Bama. Anything, anything. I know y'all watch Taylor Business. I keep going back to that because it's similar. And her, I don't know whose trial was different, and I believe um she does have a mental health disorder or whatever. It's just that she wasn't legally insane at the time. And see, there's a difference. There's a difference between being insane, right? And there's a difference between being legally insane. And to me, I don't think the defense, they may not have had enough time because he hurried up and fired them, but it was different things that they could have done to try to stand up and fight. Okay. In my opinion, we all have our own opinions, and I don't want y'all to all agree with me. Don't nobody have to agree with me. It's cool because that's how we have conversation. That's how we have dialogue. So I appreciate everybody for offering, offering their opinions. Oh, did I talk about depraved mind? I don't think I talked about that. I was going so fast, I had to hurry up and get it out. Because I think, John, you asked me about that, didn't you? And I was going to talk about diminished capacity, but let me see if y'all Y'all said something else. Going off on someone and unaliving them versus who went off on someone? What you talking about? You talking about Taylor? I think it's the same as far as mental capacity. I mean, it's two different scenarios. They both were horrific, but I think as far as their of defense attorneys fighting for NGRI defense, it would have been the same thing. They both obviously were guilty of the crime, but the burden would be proving insanity. That's what I meant. I don't know. Maybe we talk about the same person. I don't know. Yep, that's what I said. Maybe his brain, and we know it's not. I want y'all to understand. I know it's not. I know it's not. We know it's not. He's been found guilty. I understand. Okay, so it's not me taking up for him, y'all. These are just possible defense strategies. And I think that's why a lot of people don't like defense attorneys because they feel like that they're taking up for somebody who did something terrible. It's not taking up for them. They just have a right to a defense. So these are just ideas. But it could be that his brain is fried from drug use, specifically METH. He did, but it didn't work. You think what, John? I think you did. I am in a second. Give me a second. Yes. You're right. I just mean he can't say he just snapped. Oh, I get you. So did Taylor say she just snapped? Because the way she explained it, or the way I interpreted it, I guess I should say, was that she didn't snap, or did she say that? I thought well, let me see. Like I said, the way that I interpreted it was she just thought that it would be cool to do it, and she was getting such joy out of it that she just kept on doing it. So I don't know. Oh, Darrell, Darrell. Oh, hi, Kathy. Welcome. He went the wrong way down a one-way street at the gas station and believed the other drivers were in the wrong. Was he confused about where he was and what was in front of him? So he's not from Waukesha, right? So in his defense, don't chew me out, please. He did not know where he was going. He was in a different city, unaware of any type of parade or anything like that. So up until that point, that is a good strategy because, you may turn down a one way and not realize, oh shoot, I made a wrong turn. It becomes intent, it becomes purposeful when he accelerated and started zigzagging. Now, originally his defense was gonna say, okay, well, he was zigzagging trying to find gaps in the parade to get through. We know that's not true, but that was their strategy originally. I don't think they did an MRI, and that would have been something else that they could have done. They could have asked the court with that psych eval to get an MRI. Yes. And even go back as far as to when he was a child, again, what are those behavior patterns? Like, for instance, if his mom disciplined him, what was his response to that? And if, in fact, he was hospitalized at age 12, that's another thing. They could have subpoenaed those records from that stay. How did that turn out? Like, was he medicated and then he got counseling? He did okay. Like, did he speak with counselors? Did he have hallucinations like SI hallucination, HIs, that's suicidal hallucination? I mean, suicidal ideation, um, auditory. Did he have like voices? Did he hear voices? All of those things could have been questioned, but I don't think his defense, either they didn't know to do it or they just didn't have time to do it. So that's a great question. I'm with you, Bob Kitten. Taylor was having fun. She was having fun. She was having fun, and that's why her NGRI claim wouldn't work. Even if she does have some type of mental defects, it wouldn't have worked based on her own admission during that interrogation, right? Have y'all seen the Blowtown? Mhm, mhm. That goes to my malicious accusation. He believes that all white people are bad, they're all against him, and that was one of his strategies during the trial. Bob. Now compound the driving the wrong way. History of drug use, the high stress situation of an altercation, and possibility being under the influence of possible contaminated Mary Jane could have produced a state of temporary psychosis. Yep. Y'all see what I'm saying? How it sounds differently when other people say it? That's probably what I was trying to get at. But John, thank you. You explained it perfectly. That would have been a good defense. That would have been a great defense. Now, would it have worked? We don't know, but it's worth a try, right? You don't know till you try. Like Stu Harper said, he didn't just hit a group of people. He hit one person, another, and another. Kept going. Yeah. And see, I think that's where his lawyer struggled after that. He probably would have had something, okay, I drove onto the parade. I didn't know where to go. I would have just stopped. Like, I don't know where to go, so Imma just stop here. If I get arrested, I get arrested. Like, it's your fault that you're a career criminal, but I would you had rather gotten arrested. Well, would he have gotten arrested though? That's the thing. Like, I don't even think he would have got arrested if he had just been upfront and been like, well, um, I drove onto this parade route. I'm not from here. I'm so sorry. Is there a way that I can drive off of this parade route? They would have let him go. He wouldn't have been arrested unless he thought maybe that they were going to ask for his driver's license and he didn't have one. But that's just a misdemeanor if you have not called, if you haven't um committed a crime, in the act of driving, saying like before he started running people over, if you're just caught driving without a license, that's just a misdemeanor and a fine in most states. So in a tank, yeah. That would have been mine too. Hey Jason. The brakes were in proper working condition. Why not stop? After he started hitting people or when he because he stopped before he ran through the parade. And that's where he messed up at because he just accelerated and tried to just fly through the parade. So, did he test positive for anything? We don't know. They never subpoenaed his medical records. They drew blood at the hospital, but it was never mentioned. Um, Wait a minute. Let me think about that. He didn't test positive for anything other than Mary Jane, but he did test positive for Mary Jane. There was a charge for that, but Judge Doro dismissed it because you cannot have multiple charges for the same crime, if that makes sense. So he already had 6 charges of intentional homicide, and they wanted to charge him with 6 additional charges for driving under the influence causing homicide, and Judge Doral said no, and so those were, dropped. So, I don't know if anything else, uh, came back positive, but he did test positive for Mary Jane. And see, that's what I'm thinking too, Debbie. I'm thinking because of the parade taking place and they need all of the police personnel there, right? They didn't have time to arrest him. So I really believe that had he just been up front and just said, "You know what? I'm not from here. Can I please get off of this route? I'm so sorry." They would have let him out. And to my understanding, he was right by a side street. And so that's why I'm thinking, and this is just a defense strategy, heat of passion, you're under the influence, you're not thinking clearly, and you already paranoid because somebody called and said you had a knife. To him, not to me, I'm not saying I would do it, but to him, in his mind, it's easier to just try to navigate through this parade and get away than just, you know, being upfront and just asking, politely, "Can you just let me off of this route?" Oh, man. But see, I'm wondering if that coulda just been, like, what could the fit they coulda just been like, "Okay, well, okay." You know what I mean? Like, I don't know how far they could have gone with that. Why? Because they put the pause on him or because they called the police? If he had a brain injury, which could be the right side. Oh, because 'cause didn't he move his mouth like he had a stroke before? See? See, y'all? I got this good nurse on my side. No, I'm just playing. But yes, y'all remember his mouth was always to the side when he was talking. Could he have had a stroke before in the past? And it could have been drug induced. Mhm. See, y'all, I know y'all like the way I think, otherwise y'all wouldn't be here. And I respect everybody on here. I truly do. But I have taken all of the emotion out of it. I have taken out the fact that he is a jackass. I get that. I am looking specifically at the facts. We all don't like him. We all don't like what he did. I get that. But these are the facts here. And this could have very well been possible. But nobody tested him for anything. Oh, Pam, I love you. What my girl Fee talking about? Of course they would have let him out. That's why I know it was intentional. It was. There's no argument there. It was definitely intentional. But then I'm wondering, like, since he was under the influence, like I said, I think he was paranoid because he know he was under the influence. He just knew they were gonna smell the weed. Oh, I'm sorry, the Mary Jane, and let him and arrest him. But I don't think that they would have had time. It's a parade taking place. Just get your butt off this route. You think it was some gangster shit? Could have been. Hey, it was really to the side when he was ready to jump over that table on which y'all. What? Oh. Give me a second. I'm looking. I'm going through my files to see something real quick. Hold on. Mary Jane is WEED, but YouTube is very sensitive about some words. So some words I have to spell out, like sex offender, domestic V. Instead of WEED, I just say Mary Jane. Um, we say grape instead of the actual term, things like that. I bet you have. What? Excuse me. He's not. He's not. He is, y'all. Math boy fly. Okay. Excuse me, hold on. I'm looking for something. Um, so I was supposed to talk about diminished capacity as a defense. And diminished capacity ties with the heat of passion defense also. So people that are under severe emotional distress, or they have like psychotic thinking, like I said, the delusions or the hallucinations. And you can usually tell when somebody is in a state of mind of having a diminished capacity because they have poor grooming and hygiene. And if y'all remember how he looked, prior to cutting off everything. His hair was very dirty. He was not groomed at all. His beard was growing out crazily. So I thought that might have been a defense that they could have used with the ASPD to try to get the NGRI defense. Um, hey, we just throwing things out here at this point. Impulsivity is a trait of a diminished mind. They have poor reasoning ability, poor judgment. Um, Although he was oriented to person, time, and place, so they can't check that box. But I mean, hey, it could have been something that they could have tried to use where I'm at with these comments. Oh, hold on, I see a video that he was talking all hype. Oh Lord. Small man syndrome, they coulda used that. I mean, it's so many things that honestly they could have just they coulda used a variety of things, and I'm not saying they would have worked, but hey, you gotta put on a defense. You have to put on a defense, right? Think about OJ. I don't know if Bobby Boucher is still in here. I hope I didn't run you off. I wasn't trying to be mean or anything. Um, I thought about when he asked me to do the OJ Simpson trial, and I thought about his defense. We all know he was guilty of sin, right? All of the evidence pointed to him. But you know what Johnny Cochran did? He made it a racial issue, right? Because he knew at the time that the LA police officers were corrupt, and there have been several uh cases and accusations about how they treat black people upon arrest. He played on that and he tugged at the heartstrings of the jury and won, even though that man was guilty. Right? Right? Now, he didn't unalive six people and injure a bunch of others, but still, it was two unaliving cases, and he got off. Did they disable his Twitter and stuff? Oh, no, good. Uh-oh, here go my girl Fiend. Y'all are funny. Y'all are funny. Mhm. But that was about race, right? Didn't Johnny Cochran feed into race being the issue? It worked. Where was the TV at? What is TV in the front? The TV, the front. Where was the kitchen? So the kitchen was in the back seat, or did he have a kitchen, John? Right, exactly, exactly. And see, you have some defense attorneys are so skilled that they probably could have got a manslaughter charge. Seriously, you got some attorneys. Think about Alexi Treviso, y'all. I know y'all heard about that little girl that unalived that baby in the bathroom. We all know she's guilty, she's wrong. To us, there's no defense, but her defense attorney is so confident in his ability that he took it upon himself to file a lawsuit for them, blaming the hospital. Why? To take our attention off of what that little girl did. He's going to blame somebody else. That is what the defense does. You're going to take all of that off of your client. You're going to point the finger at somebody else. Just like Johnny Cochran successfully did for um OJ. He wins it every day. Oh, the kids. Where did he have a TV at? John, you are a mess. So the front seat was what? The dining room with the TV, In the back was the bedroom, he had no kitchen. Is that why his mom came out there to bring him a little piece of change for him to go get something to eat? Oh, I have to watch that film. Yeah, so and you know what, y'all? Honestly, I think a lot of us with these defense strategies, since we've already been privy to a lot of the evidence. We've already made up our mind about the case based off of the evidence, right? But I want y'all to think in terms of a defense attorney that doesn't have all of the evidence yet. You can't tell me some of those defenses were not going to work. I dare y'all to. I dare you. Right. Didn't she say she gave him a TV and then something else? A mess. The Lincoln lawyer. I'm about to put that in my phone. No bathroom. Mm-mm. He went in that house, didn't he? Or on the side. Maybe in a tent. Now, also, if I was his lawyer, I try to play the race card because during that time there was still, yep, George Floyd. I mentioned that, didn't I? That's what Darrell tried to do. Think about it, y'all. The malicious accusation, right? He knew all of his witnesses, all of the state's witnesses were white, right? He thought all of them were against him. He thought the prosecution was against him because they're white. And then, um, therefore, he thought everybody had it out against him despite what he did or didn't do. Y'all already not gonna like me because I'm a black man in America. Oh, okay. That too, Sparky. But you know what? That's when the defense should have put in a motion to suppress that evidence. I need y'all to suppress this evidence. I would have fought hard for that. And in that way, if it's suppressed, what you gonna do? You can't talk about it no more. So, like I said, I don't know if they didn't have enough time. I don't know what their strategy was. I don't know why some of these things weren't done, but that's what I would have done. Mhm. Uh-oh, what Jay Prince say? Yeah. Mhm. There were over 300 videos, Bob Kitten, of evidence. But again, the defense, had they gotten that evidence, or I don't know, well, they had it. I have not read anything. The only thing they tried to suppress was uh God, I gotta go back and look at it. They only made one motion to suppress one piece of evidence. And then they tried to get the case dismissed because the whole jail cell search thing. But they didn't take their time and try to figure out what they could suppress. And that would have been one of them. Um I want to suppress these phone calls because to my knowledge, and I don't know if it's to the judge's discretion, I do not believe that phone calls are admissible in court. I would have put a motion in to suppress his social media accounts. I would have tried to get the video of the picture of him in those videos suppressed. You got to try. Let me see. Hey, is it Shakik? I don't know how to pronounce your name, and I'm so sorry. That's different. Okay. She helped him. He helped her when she had them seizures. Okay. Don't you dare come on here. No, I'm just playing. Yeah, but I think he has an issue with white men specifically. Honestly, he didn't like Suaper because Suaper is intelligent. He doesn't. Okay, so here's the thing. He doesn't like white men. He doesn't like women. Period. It doesn't matter your race, especially if you are in a position of power and you are intelligent. Okay, that was a threat to him, so that's why he couldn't stand her. Exactly. If I were his defense team, I'd bring a doctor of psychology or those doctors who are with people with anger issues and psychosis. Hi, Sophie. Then use evidence when he argued. Thank you. Thank you. That was one of my defenses, girlfriend. I don't know if you got to hear it, but that's what I said to them. I said that. That is what I would have used. I would have tried to tie all of it. Drug use, anger issues, heat of passion. I keep getting into it with this woman and I adore Erica. But look, I got to protect my client. I keep getting into it with this female and we argue and fight so much so that I just become enraged and temporary psychosis. And then my little nurse boo on here already said they didn't do it. Did they do an MRI? Does he have a brain injury? Like it's so many things they could have used. And like I said, I know it wouldn't work because this is post trial. So we already know enough, but, thinking back to those pre-trial days, those are all things that they coulda tried to use. I'm the first one to scream when ways of presence evident, especially in the justice system. Right, it wasn't one of them, but you couldn't tell him that. That's another one too, that's a good example. That is a very good example. Mhm. Yep. See? I mean, there's idiots that actually believe Shaka Zulu was the first man on the moon, but white people are suppressing the knowledge. Yeah, I do not believe he did this to kill white people. Right. I don't believe that either, Debbie. I just think that what do I think? I think that he was pissed off with Erica, which was not anything new. I think that what enraged him even more was the fact that, and I think I said this in the last video that I did, that he was even more upset because Nick and Corey were there to help her. Now you got to think there have probably been many a times where when he abused her, no one was around, right? And so he was able to just do what he did. She probably apologized, and that was the end of it. He went his own way, she went her own way, or they probably stayed together. But in this case, you got two, and I'm not trying to be mean or derogatory, white people, okay, that came out of nowhere that she just met. Because remember, these are people she met at the shelter that are coming to her aid, right? And they are helping you by physically putting their hands on you. Okay. They're helping Erica by fighting back, I should say. I say it that way. That pissed him off even more. And then you got the audacity to call the police on me and say that I have a deadly weapon, right? And I think that just pissed him off. He's already under the influence. He already is not supposed to be meeting up with Erica, right? He's already on probation. So now you're a violation of your probation. He drove away in a rage, not knowing where he went, and just drove to this parade. But like I said, if there had a been any type of clarity, a moment of clarity for him, he could have got away and just went on home until it was time for him to face trial for his nephew. So no, it wasn't a racial issue at all. I don't think that he intended to set out to kill white people. You're right. But I think that in court he was just trying to make it like, oh, well, all white people are against black people, and then he brought up via his tweets the George Floyd incident. And so he was trying to use that as a way to say, everybody's out against me. And that's part of that is his personality disorder. He's highly paranoid. And it doesn't have to make sense to him to us because it makes sense to him. And so to him it's right because that's what he believes. Oh. He wasn't afraid of Zach. He was ready to put the paws on Zach. What you talking about? If it wasn't for them shock devices, okay? Yes, he hates strong women. And I think that's why he despises his mother so much too. Because, if it's true that his mom was abused and God knows how long she was abused, I think that's why he despises her and doesn't have any respect for her because she lets him get away with anything. She makes excuses for him even though he knows right from wrong. I don't think she ever took the time to put him in his place. She never did anything to correct him, okay? And so for him, he likes weak women around him. His friend that spoke at the sentencing. His grandma don't seem like a strong woman to me. His mom, I don't wanna say Erica, but in a way, yes. She wasn't strong enough to fight him off either because she was abused so much, so no. He is intimidated by authority, by power, and women who are in those positions of power and that are intelligent. They tried to? Okay, and what happened? It didn't work, huh? Oh, you're right, they did try to suppress, but see, they went about it the wrong way because they said, and we can watch it again if y'all want to, just a small part. His defense attorney said that they did not Mirandize him, but what the reason why it didn't work was because when you're being detained, they don't have to Mirandize you because they're just asking you questions. They're getting, excuse me, evidence to gathering evidence to get a probable cause warrant, a probable cause affidavit to get a warrant to arrest you. So they didn't need to Mirandize him, and then they claimed that he said he didn't wanna talk no more, and they kept talking, but they didn't ask him any more questions. He asked them questions, and they gave vague answers, so that's why that didn't work. He doesn't like anyone yet. Nope. Yes, that's right, Sophia. I mean, Sophie, I'm sorry. You got a lot of people, everybody think about when you get mad, like you can't rationalize anything. You're emotional. When you're emotional a certain way, you cannot think. And I'm not making excuses for him. I'm just saying, the average person, when you're upset, you try to talk your way through it. And if you can't, then what are we taught? You just walk away and calm down, right? But if somebody grows up not being taught that and you're just enraged, any little thing sets you off, it's just like you're just gonna keep on going until you explode. He doesn't know how to sit down and rationalize anything. And to me, I feel like that's something that your parents teach you, right? Like when you discipline your children, you know, you discipline them. Well, I'll say for me, when I discipline my children, of course, they're upset with me. But then I try to have a conversation with them afterwards to let them understand what they did wrong and how to correct their behavior, right? You can't just get so upset to the point where you go do something dumb. That's not smart and that's not realistic. And I feel like that's how he grew up. He just grew up doing what he wanted to do and his mom not correcting anything. And so now we got this anger issue. That's something that you got to tap into when your children are young. You can't wait until it gets too late and then you're making excuses for them. See? It's a lot of people like that. And so, again, I don't know if that's a personality disorder, but for me, I feel like you have to at least try when your children are young to correct that behavior. You have to get your children to understand their emotions. You have to teach your children to be able to talk through things. Like I said, rationalize, and if you feel like something or someone is upsetting you to that point, you don't need to be around that person and you need to stop doing that thing that upsets you to that point. You need to know what your triggers are and you need to know how to de-escalate, right? What was some Mexicans? Y'all know I'm behind on these comments because I keep talking. What you talking about, Fee? And because Erica wouldn't bow down. Yep. Nick and Corey punked him. Yep. He was long ass, broke. People in a row. It was just the same. Yeah. Yep. He was on bond. He was on probation. So, oh, Lordy. As far as what? Tell him what happened? Or to be honest with you, I don't think he ever had if we're talking about what he feels happened or if it was right or wrong or whatever. I don't think he ever had that conversation with them. I think that he just met with them. They told him what he was facing. They explained to him the severity of it. And I think he just talked to some people, maybe some people in the jail, his mom. And I think that's when he just tried to do the NGRI. And once they told him that the ASPD alone wasn't going to work, that's when he just said, forget it. I don't need y'all. I don't think he ever told them anything, to be honest. Excuse me. Mhm. Could be. That will go with heat of passion. And that's why I would have petitioned a court to see if I could have gotten 3 at least 3 different psychiatrists to test him for all of those issues. A retest for bipolar, schizophrenia, rage, anger, put everything on a list. Everything that you could think of that can tie back to this. And no, we're not blaming Erica at all. We're just thinking of strategies, you know. So yes, like I said, before when he would abuse her, I'm pretty sure nobody was around. But again, you got to think about his paranoia and how he feels against white people. And those two together, y'all fighting me back. Y'all taking up for her. I don't know y'all. I don't know where I'm at. I'm under the influence. Yeah. Do you really think she's afraid of him? I know he beat her up in the kitchen one time. Mm, let me see. I would have paid to see it. Right. Now, only reason she didn't let him in the house is because of the restraining order that the nephew had, and I think it was one against the mom had one against him as well, I believe. But I think that had the nephew not got an order of protection, she would have let him back in the house. I think that you got a lot of mothers out here that don't do right by their children when they're young, and when they become adults, they regret decisions that they made when they were children, and they will do anything to protect them. They will do whatever they gotta do. It doesn't matter if it's right or wrong, they will fight for them and with them, and that's what I believe Don did. Another example would be, I don't know if you guys heard of, her last name is Komrowski, I believe. She is a young lady that, got intoxicated and drove her car into a golf cart of this newly wed couple, and she was sent to jail. She's awaiting trial, but her phone calls were released with her parents, and her parents basically told her that she didn't do anything wrong. I'm going to do a video on that. She did not do anything wrong, and that they were going to fight for her. They were going to get the best attorneys possible. That is an example of that. She is spoiled and entitled. Daryl isn't. I'm just saying this young lady, and that's not good. Because now she's growing up with no type of no sense of accountability. I can do what I want, but it's gonna be in my favor because my parents are gonna protect me no matter what, and that's not good. Sure did, and I was ready for it. I don't believe he thinks all white people are against black people. Hmm, I don't know about that. Just based off the tweets that I read, and I'm sure a lot of other people have read, I'm not sure. Now he could have just been running his mouth just for the sake of feeling like he belonged to a group of people who really do feel that way. It could be that. But based off of what I read, I don't know. I don't know. Yeah. Oh, nope. Hey, Sadie. Y'all hear my kids playing, just go with it. Y'all know they love to play. Who is Ryan? Which one is Ryan, y'all? That's the investigator? Now, let me tell you something. I told y'all about my childhood, most of it. My grandmother raised me from age 10, and there's no way. My grandma had the whole neighborhood looking out for me, the whole church, the whole school. She knew everybody. She knew my every move. and she was not afraid to whoop my ass if I got out of pocket. His mama, maybe she was scared, I don't know, but we had this conversation last live. She should have done something. There were things that she could have done and she chose not to. Yeah, he is. Which one? Oh, I know who you talking about. Oh, Sophie, I did a video where I read a report from a spectator's point of view, and it was terrible. I am very glad he was finally found guilty for something. I hate that people had to die and, of course, be injured, but he wasn't gonna stop. He's a menace. He said niggas were white people. Oh, they Mexicans? Oh, my fault. My fault. That would be nice, but I'm telling you, I think that he fired them because once he realized that that NGRI, defense wasn't gonna work, and they tried to tell him that, and they probably told him, "There's really not a defense that we can use for you," along with whoever was feeding him that soft sit stuff, whether it be his mom or whoever else, he felt like, "Okay, well, I'll just take all the work that y'all did, and I'll figure it out on my own." I really believe that's what happened. They never I know when they were leaving court that day, they, were asked to be interviewed and they declined it, and they probably can't talk about it either, but I really feel like that's what happened. "Hey, Maddie." Yeah, I read somewhere where he beat her up in the kitchen, excuse me, and she had to call the police on him. "Hi, Kimberly." Who thinks mama Jocasta, what's that? Comes for some because they will screw someone too. What's that? I don't even know what that is. What's that? It is hard. It is hard. And that's why I'm always talking about taking the emotion out of things. The emotional part of her, probably as a mom, was like, I can't have him in there. But what I really hate is the fact that she helped him come up with a plan to basically screw Erica over. That infuriates me. That infuriates me. And even to this day, she got on the news. She gave up, her sentencing remarks or whatever you want to call them. She not once ever apologized to Erica. She never mentioned Erica at all. She does not like her. And I think that she doesn't like Erica because Erica is strong. You got to think about something. Erica has been abused for 16 years and she's still trying to hold her head high. Okay. She goes to work every day. She's still trying to do the right thing in spite of can't stand that because her raggedy ass son can't get his life right. And this young lady, even though, she's been through so much, she's still trying. She's trying to be better than what she's been through. And she can't stand her for that. Why do you think Don said he didn't get a fair trial? Girl, Miss Terry, let me tell you something. Dawn just wants something to say. Dawn wants to save her son. Again, I think she just wants to protect him because she knows she didn't do her due diligence as a parent when she had the opportunity to. And so she's just grasping at straws like a defense attorney. I got to figure something out. Got to figure something out to help my baby boy. That's all that is. It's really no rhyme or reason, right? There's nothing it will never make sense to us because we won't do anything like this, right? I think the bulk of us, if our children do something wrong, we're gonna reprimand them, And she's pathetic. So, you know why? Because that will be considered a heat of passion defense. and that would be involuntary manslaughter, and you can get off on that. And if you're found guilty of that, you can appeal, and if you throw yourself at the mercy of the judge, you can get out. And I'm gonna give you an example. There was a young lady in PA that was being abused, and she went home, and her kid's father threatened her, and she unalived him with a GUN, and they threw out the manslaughter charge, and she's out on appeal. It was a heat of passion defense. So in some instances, it can work. It just depends on what your defense attorney can do for you. I'm sorry, I'm so behind y'all. So if I ask you what you're talking about, it's just because I read the comment long ago and I forgot. I'm sorry, Debbie. What interview? I'm sorry. Don't cuss me out, please. Probably. Like, she's a coward. Okay. She's a coward. And that's just that on that because Waukesha is only 14 minutes, 18 minutes from Milwaukee. You know, she could have come. She's a coward. His mom paid for his cell phone and his basic needs. And I believe when he was in the other states, in Nevada specifically, Michelle took care of him. And that's why I think in turn he took care of her, such as helping her when she had a seizure and whatever she said. That was where he lived so that she could take care of him. Now, when he was in Georgia, I'm not sure, but his mom provided all of that for him. Who you talking about? See, I'm so behind. I think Ryan is it's the investigator. Now he was nice looking, y'all, and that man, that officer with that red beard too, y'all. To be honest, he did feel like the time was against him because he was black. I think so too, ma'am. It was, Sparky. Yeah. Hey, Beverly, his steak and mama bought him that phone. I had a real daddy. He was not playing those games while his boys being street dudes. Absolutely. Absolutely. Tough love, right? They'll thank you later. My grandma used to tell me, either I'm gonna have you or the streets are gonna have you. Which one is it gonna be? Right? Either I'm gonna discipline you or you gonna get out on the street and the streets will have its way with you. You tell me which one you want. And it's just that simple. That's true. Let's say I've been saying that from the beginning. How's he alive? You know what? Some people just have street smarts and they know things that us people that abide by the law don't. And they can just maneuver through society and get away with things and survive. It's crazy. A woman. What? Oh, you know what? I heard of a case. Who? I heard of a case of that. I just can't think right now. Hey, Christine, how you doing? I'm way behind in these comments because we having a great conversation. So just chime in when you're ready. I'm making my way on down the thing. I don't think he had much male influence growing up. Well, no, I think he just had that pseudo granddaddy, the good Dr. Mary, Darlene Edwards' husband. But other than that, no. Mm-mm. But you know what? There are a lot of men that grow up without fathers and they still grow up to be productive citizens, right? So again, unfortunately, your father left you. I'm sorry. I didn't grow up with a father either, but that does not mean you had to be a criminal. It's just, you know, it's one of those things. He made a choice. He made a choice. But I don't believe that he was evaluated enough, but he made the same choice over and over and over again. What was his plea deal, Maya? Because I was trying to look that up to see if they offered him one. Baby boy. That's her baby boy fee. Okay. Yep, she was helping her son and sent those pictures on trial. She created a monster. She did. She did. Mhm. I think she spoiled him even more so when he became an adult, and I think that's what she probably tries to use, as a way for him to stop committing crimes, but it didn't work. It's too late. What you gonna tell somebody that's grown and a man at that? Mhm, mhm. I think that's another reason why he really can't stand her, because after all of that, she's not somewhere crying and feeling sorry for herself. She went to work and in a totally different state on top of that. To me, that speaks values about her character, right? You're in a different state where you don't know anybody. I don't know if she's still in the shelter or not, but the fact that you get up every morning, clean yourself up, and you go to work and you're not complaining, that's why and I think that's what pissed him off even more when he brought her to back to court to examine her. She looks good. She was clean, had on a nice outfit. Her hair looked nice, well groomed. She stared him down. You're not going to intimidate me. I'm doing well for myself and I'm over you. Pissed him off. Sure will. Look, I don't have a problem disciplining mine. All three of them, they know. His mom said, I talked to Erica. You know what? Let me tell you something. She couldn't even address her by name. I called her and I asked her, did Darrell do what you said he did? Girl, I think that was the victim and her not wanting to acknowledge another victim, really. But either way, she trifling. She trifling. I will never say anything good about Dawn, and I don't care who doesn't like it. I think she was, and I think I heard that that was why we don't have access to his phone calls. It's not because he's awaiting appeal. It has nothing to do with that because other individuals that are in prison are also awaiting appeal, and their court information along with prison calls and jail calls have been released. So it's not that. So it could be, I don't know. I don't have that in front of me to where I can say it's true or not, but most likely. Yeah. Do you think that little boy that she had at the, sentencing was his son? That cute little boy? Yeah, he did. Oh, yes, you gonna be yep, that's right, John. Mhm, mhm. One officer, I'm not sure about his name, but I was like, I'm going with Oh, Sophie, you bad. Which officer? I think was it the one that was on the stand the first day with the blonde hair? So it really was his father that did the bomb threat? Oh, I probably shouldn't have said that. Oops. The threat. Mhm. There are a lot of women that are strong enough to just do what they gotta do and raise wonderful children. And I mean, it can go either way. You can raise a child that you think is gonna be good and they still do what they wanna do, but that's not your fault. And you won't make excuses for them because you know deep down inside you did everything that you had to do. And then you have some kids that aren't entitled, they don't grow up entitled. You love them, you taught them everything that you could, and they grow up and they make you proud. And that's why I keep saying that with Darrell, you know, people got mad at me and people are still upset with me, but it is what it is. We are all given the opportunity to be great in life, right? from a young child, if you have the right village around you and they are nurturing you and loving you and raising you to understand the difference between right and wrong and really pour into you and help you learn your gifts and you hone into that and you go to college or you go to trade school, whatever you decide to do and grow up and do the right thing, you can be somebody. Seriously. And that's what could have happened with Darrell. I don't think he was given that opportunity at a young age. I really don't. And I will say that until I don't have this channel anymore. And I think when he committed his first crime, that was that. He got a taste of it and that was that. Had he not done that, who knows who he could have been. With the right education, the right resources, the right people around him, people just gonna have to be mad. I feel how I feel. He chose crime instead of potential. No, his mama wasn't strong. She weak. She's still weak. She's gonna always be weak. Um, well, I mean, it wouldn't have made a difference either way, right? I don't know. What would you have chosen? I guess in his mind, it's like it don't matter. But in his mind, he just knew that he was gonna prove that it wasn't him. He wasn't guilty. So I don't know. Oh, excuse me. Excuse me. Oh, mine'll be 18 in 2 years. I'm scared. Yeah, I get you, nurse. Right. But you know why he was doing that. He was doing that to get under her skin and just have some type of dominance over her. Or no contest. Mm, okay. Mhm. Right. Sophie, don't go out there stirring up nothing now. A dear around here I know told me that the plea deal he'd offered was uh, oh, okay. Well, oh well. I feel that way too, Terry. A lot of people are upset with me about it, but like I said, I think that, if he would have applied himself at the right time, who knows? Who knows? There are a lot of people that commit crimes. I know somebody from Cincinnati did something stupid, went to jail, and realized, okay, I can't live my life like this. He got out. The University of Cincinnati gave him a scholarship to go to law school, and he is a defense attorney now. You know, um, a lot of criminals are not dumb. They just do dumb things. And a lot of them, they do dumb things because they don't believe in their potential. They don't have the right people around them. I mean, I can go on and on about that. And so it's easier to them to commit a crime than apply myself to do something else. What when he during trial? Yep, he did. He did. Now y'all misbehaving now. Y'all just in here cutting up. Oh, look at Miss Bama. She done joined y'all. Oh, goodness. Darrell. It probably will. And you know what? Who knows? Maybe he'll be good at it. We don't know. He did a terrible thing, yes, but we don't know. Maybe this will help him focus on something and he can figure out what his calling could have been. It's not for me to say. All I can do is comment on the horrible things he did and just shake my head. I'm not here to determine what Darrell could have been or couldn't have been and speak badly about that, you know? But hey, this could be a time for him to find himself. It's too late, but hey, I believe that too, Debbie. I believe that too. But I think again, I think a lot of people are just caught up in the emotion of what happened that they can't see that. And that's okay. I'm not here to make anybody think and feel how I do. I just ask everybody to be respectful. And I'm not fussing at you, Debbie. I'm just saying, but I don't think he's dumb at all. I really don't. I really don't. He was reading off of papers that he didn't understand because I believe there were outlines. And yeah, had he been properly trained, he probably could have put up a defense with the right words and all of that. I'm telling you. I'm telling you. Oh, Christine, you be eating good. What you get on your pizza? He is from stupid. He could have been. He could have been. I'm telling you. Think about this. We all know he put up a terrible defense, and we know why. If you think about every day when he came to court, right? We all got glimpses of him before the Judge Doral took the bench, right? He sat there, he got all of his stuff for that day when he was trying to aggravate Erica. But for the most part, his boxes were neatly placed on the table or on the floor. He had all of the documents that he needed for that day in front of him in order. It wasn't like it was just a bunch of chaos on the table. He was able to take notes. He was able to listen and follow through. He was able to ask follow-up questions. Now, he couldn't interpret the law, but that's because he's not trained in the law. But to me, that's not a dummy. It's millions of people can't interpret the law is hard. If you're not trained in the law, you're not going to understand it. You know what I'm saying? And I think that's where those tantrums came into play because he really didn't understand some of those concepts and he was frustrated. And think about it like how a child would react, right? With this ASPD, we all know he's very childlike. He doesn't have the mental capacity to think as an adult most times. What do children do when they don't get their way and they don't understand something? They show out. That's where I believe all of that came from. And that's not taken away from me knowing that he's guilty and he did something bad. I'm just saying, to me, somebody that's stupid or dumb, I wouldn't have seen that type of behavior. Somebody sitting there organized and waiting for you to get started with this trial. But that's just me. Mhm. But see, Sparky, do you think that had to do with his personality disorder? And if so, I know they say like with ASPD, it has to be treated at a young age. So from my understanding, ASPD in children is known as oppositional defiant disorder. So with the right medicine, like his mama said, and the right treatment, like his mama said, do you feel that he could have I guess I don't wanna say recover, but been well enough mentally to where, he could have been better. What do you think? I hope I worded that correctly because sometimes I don't say the right stuff. Oh, now John done joined in. Y'all something else. I want some pizza now. Look, Darrell, Durrell. Okay. If he studied hard, he coulda. He coulda. Yeah. See, this time, yeah, the evidence outweighed the defense. Absolutely. Absolutely. Ooh, excuse me. I believe that, Maya. I'm glad you said it because I'm tired of them cussing me out about it, but I believe that. I believe that. Mhm, mhm. I do. Mm, maybe he was taking notes so he could take it back to his mom to get clarification from her boyfriend or whatever. Maybe that type of thing. Like maybe he was writing it, such and such said this, and what should I do about it? Or Who knows? Maybe he was writing his novel, his autobiography. I don't know. Oh. A brilliant, prosecutor or defense attorney? I think he probably could have been a good defense attorney because defense attorneys are trained to use trickery as a defense, and I think he would have succeeded with that. So you already got the street smarts, right? Somebody would have set you down and taught you the law. You went through and got your bachelor's. Let's say he did a bachelor's degree in criminal justice. So now you know the ins and outs of, how criminals think, which, he already had a one up on us with that, and how jail works, policing works, ethics, all of those things. And then somebody gave him an opportunity to go to school so he can really learn the ins and outs of the law. He probably could have excelled as a defense attorney. I'm serious. Not sustain. Or maybe, you know how she kept making him, what did she call it? Pledge to the court that he was gonna behave, so maybe he was getting a lot of them written down in advance, so when she held him in contempt, he could just pass that over to the bailiff and they can bring that over to the judge real quick. Oh. Oh, right, right. Oh, man. Yes. Yeah, that's how I feel too. Women. I think his social environment was never gonna support him getting well. I believe you remember, were you on that live that time when I said that, a lot of times when criminals are released back into society without any type of rehabilitation or diversion program, a lot of them go back to think about it, a lot of them go back home to their moms, right? Right back into that environment, and they're just, I believe, enticed to do the wrong things. Like I said, a lot of times it's easier for a criminal to just, what we call recidivate, as opposed to figuring out a different path. It's just easier for them because they're too lazy or they don't have the resources or the support to figure out a better way. Uh-oh, here goes my girl Fee. Fee is not having it with us. Okay. She said she is sick of hearing us giving him okay sympathy and whatever else we in here doing, and she about had it. Yep. What do defense attorneys do? Don't they manipulate and use trickery? Mhm. Oh gosh. Dawn is full of shit in that order. All right. She ain't help him with nothing. That's why she ran to the news to try to save face. She knows she didn't do nothing with them kids. And I can't speak on his sister, God rest her soul. But as far as the real, I know for a fact she didn't do anything with him. I know she didn't. But try to protect him as an adult when it's too late. That's all she did. Okay. Y'all are so funny. How long we been in here? Hour 40 minutes. All right, we can watch a video. What video y'all want to watch? I know y'all want me to do yellow shirt day. I don't know if I'm prepared to do, excuse me, yellow shirt day. Y'all tell me, because I gave y'all all of the defenses I had. And I really appreciate y'all for chiming in about these defenses. We have had a good time with this, although we know they would not have worked, but we can wish, right? We can wish. Oh, somebody did ask me a question. God, I can't remember the person's name. They asked me why I thought that the state did not charge Darrell with driving without a license, and I have no idea. I did try to look it up. It would be considered a felony since he unalived people while driving under suspension. or whatever it was. And so I don't know if they just felt like he already had enough charges and they just didn't charge him, or maybe they just missed the opportunity to do so, or it could have been it. I know they can't excessively charge you with things, and so it could have been that. I'm not exactly sure. I will keep looking for the answer though, but I did say that I would address it on the live. And then they also asked me about count 77 and why if they had um I guess if they had could they have checked the cell phone towers for proof that the incident didn't occur? So it wasn't that they didn't think the incident they didn't believe that it occurred. They know it did, but they didn't have it was lack of physical injury. And so they just decided to drop it. And also, how did that go? Hold on. Judge Doro also said to drop the another charge related to Erica because hers was an isolated event, and it wasn't a part of the mass casualty. So there were 2 charges originally for Erica, but one was dropped or something like that. I gotta go back and read it again. But the count 77 was dropped because there were no physical no visibly visible injury, sorry, on Erica, so they dropped it. So I hope that answers the question. I'm sorry I'm stuttering. I had some coffee today, so I'm a little jittery, so y'all just mind y'all business, don't judge me. Sugar, honey, ice, and tea goes hand in hand with father, uncle. What you talking about, Sparky? Why do y'all want me to do yellow shirt day so bad? What y'all think Imma say? Now feet done started. Y'all done got my good sis feet started. What am I not reading right that Sparky said? I'm tired. Right, right. But why buy a car if you can't drive and your son doesn't have a license? First of all, what I really want to know, now I only bought one car in my life. Well, two cars. One car I bought on my own, another car I bought off a family member. Um, I know when you go to buy a car, right? You gotta before you could drive off the lot, you have to have proof of insurance. Now, as to my understanding, Dawn didn't have insurance and she did not have a license. So I don't even know how she was able to buy the car. And then when you go get plates, you gotta have your proof of the driver's license. And is it insurance as well? I can't remember. It's been so long. But I know for sure shoot a license. So I don't even know how she was able to buy the car in the first place. And it was in her name. So it's not like somebody else bought it unless somebody else bought it. But even if somebody else buys it and puts it in another person's name, you gotta have your license when you go get the title, right? Could be. And maybe, just maybe, Sparky, maybe that's why. I remember my last video, he got 38 hot. Maybe that's why he was so upset and really trying to circle the block on that one. What y'all think? That's another defense strategy, ain't it? Oh, y'all showing out. Oh, I see what you saying. Thank you, y'all, because you know sometimes my brain don't work as good and as fast as I would like it to. Oh, wasn't he? I mean, what? Yeah, he was. He was. He was. So I'm wondering, so November 20th, I wonder if that's gonna be a part of the upcoming trial, if they're gonna bring it up then. What y'all think? I'm not sure. I hope, I did a good enough job for y'all. I know y'all were anticipating me giving these defense strategies or whatever. I did the best I could with what I had. Like my girl Mariah Carey likes to say, there really wasn't much for me to go on because we all know he is guilty of sin. But I did my best and I put in the research and I just hope that y'all appreciate, the efforts that I took to make this little live for y'all or whatever. I really hope y'all do. Sparky. Do you feel like so here, Sparky, how do you know the material? You know what I do? I make my kids sit down and listen to it because if I can teach it to somebody else, that means I know it. So, can you teach it to somebody else? That's another reason why I started this channel too, because that lets me know that I know the material that I was taught. And I must be learning something because, y'all always telling me I did a good job and thank you for breaking things down. And I really appreciate y'all because let me tell you something. Studying the law is not easy. It is not easy. Um, and I'm not a lawyer or anything like that. This is my second career that I'm studying for. Um, but it is just very fascinating to me and I can't get enough of it. So this channel really helps reinforce um what I've learned. So that's what I try to apply, and that's why I always say take the emotion out of it because that is one of the first things that they teach you when you start studying law. You can't go in as an emotional thinker. And so I think that's why a lot of people when they watch my videos and they get ready to comment, they're thrown off, and it's not that I don't know what I'm talking about, or it's not that I don't know the case, or I didn't watch the case, or anything like that. I just have to approach it from a different aspect, like how somebody working in a legal field would, right? And so, you take all of the emotion out of that, and sometimes we hear things that we don't agree with or we don't like, but that's just how the law works. And so that is my motivation behind conjuring up the courage to do these videos every day or however often I can get them out because I want to reinforce that I am learning something. And so I hope y'all appreciate it. I really do. Well, I guess y'all do because let me do a subscriber check because I like to keep y'all posted because I have to show my appreciation for y'all. We are at 546. Let me tell y'all something. Didn't I go live Thursday night? We were at 517. No, we weren't. We were at 500 when I went live, and when I did that video the next day, we were at 517, and now we are at 546. Okay? I appreciate y'all so much. I really do. I really do. Let's see what we got going on in these comments. I did my best, John. I really did. I did not have much to work with because there was so much evidence, but I tried to research as many defenses as I could. And I think we just gonna go with the maybe possible brain injury coupled with drug induced psychosis and a fueled rage, and we just gonna call it a day. We probably lost in court, but you can't win them all, right? Thank you, Frank. I appreciate it. I do. I second guessed myself many a times because I'm telling you, it is not easy. Either way, prosecution or defense, it is a tough job. Thank you, Christine. I appreciate y'all so much. Thank you, Miss Terry. You probably right. You probably right. And you never know. Maybe that is the way God is steering my life. Maybe I found my calling. It is never too late in life to find your calling. God will put you in a position for you to have everything that you need as long as you do your part. And I feel like I am doing my part. And if that's where I am led to go, then I am asking God for all the strength to get me there, right? What? No one else in my social world wants to hear about this topic. It's currently on serious. It's hard to find a lot of people that like true crime and stuff of this nature, but hey, you got a community over here, so you can always talk to me about it. I'm always here to talk about it because I can't get enough of it. I love the law, I feel like. Well, take it, DMV. What's that? You live in Louisiana. Do you have to is there a baby bar there, or is that only California? I love it too. Go for it. It's never too late. Thank you, Bama. You know how I feel about you, Bama. Thank you. Thank you, y'all. Oh, medicine, what type of doctor does she wanna be? Is it, like, mental health or is it, like a DO? Whoo, John. I really believe that if they had not been fired, I think they just would have tried to make sure that they're try to see if there was some loopholes in the prosecution's theory. Nothing would have worked. Nothing would have worked. I think maybe if he just only hit one person, possibly they probably could have got it down to a manslaughter charge, like voluntary manslaughter. But other than that, there was nothing. I'm serious. There was nothing. I looked at all of the defenses for a murder charge. None of them would have worked. Nothing. And I know a lot of people were thinking, okay, well, NGRI, but no, no, because he doesn't have the mental defect for it. So thank you so much, Sparky. Thank you. Oh, John. Is it 11 o'clock already? Oh my goodness. Mm. Well, I want you to have a good time, but if you could check in, please do. Oh, I don't know what any of that means, but okay. Sounds good. Just apply, right? Okay, well then you do it so then we can all come over there and see what you gotta say. If I can start a channel, you can. Y'all need to go to my about page and look when I started this channel. I started this channel in 2013 and I was just sitting on it because I was so worried about what people were gonna think about anything. Like I was just like, oh my God, I hate my voice. I told y'all when I talk a lot, my sinuses drain, so I'm sniffing all the time. Oh my goodness, I just let everything get in my way. I just had this fear that nobody was gonna listen to what I had to say. And so finally I was just like, well, whatever, if y'all don't like it, y'all don't like it. Somebody's gonna listen. Like, girl, start that channel and apply. Apply. What you gotta apply to law school? You have your bachelor's already? I'm here for it. I think Bama gonna try to, sneak in and bless us with her presence. Okay. Be sassy. Who gonna stop you? I'm not, because soon as you make that channel, I'm gonna be the first one over there, waiting and listening. Say what you gotta say, just like I say what I gotta say. I am at the point in life where I just don't care. You know what I mean? Like whoever's for me is for me. I cuss a little bit. Sometimes I can't pronounce words, and I'm not ashamed of it. Hell, sometimes I just can't. My kids scream in the background. All right. Sometimes the audio is jacked up. Uh, Sometimes I might get the facts wrong. I just don't give a damn. Either you like it or you don't. And I'm not arrogant, but nobody's perfect. And I think that's why a lot of people, get burned out with YouTube because they're so set on being perfect and all of this stuff, and that's not realistic. People want to see somebody that's real. Okay, I'm real and I like to get to the doggone facts. I'm not going to sugarcoat anything. I respect everybody. I am open to healthy dialogue. I give everybody a chance to say what they want to say as long as you're not being disrespectful to me or anybody else, and we just going to go with it, right? Right? Girl, start that channel feed. I'm waiting. I'm going to be the first one over there. The first one over there. Thank you, Christine. Thank you, Bama. I'm not. You can't let these people push you over. Look, I probably will never meet none of y'all. I respect everybody on here, but I can't go to bed worry at night worrying about who has something to say about whatever. You know? Even if this channel was perfect, I got everything correct. Somebody's still gonna find something to complain about. So that's why I don't give a damn. Okay, so what you waiting on? Did you take the LSAT? Take the LSAT, and let me tell you something. Next year, You might be at an advantage. I don't know, like, if you like the logic games part of it, but they got rid of that, so it'll just be 2 analytical reasoning or something like that, but I think it's gonna make it a little easier. So and your LSAT score doesn't have to be really high. The average is 151. Work on your personal statement. Get your letters of recommendation. You only need 2. Girl, and let's do this. Okay? Okay, let me read what my girl Sparky saying. Rural remote, Outback Australia, the most. Oh, okay. I got you now, Sparky. Thank you so much for explaining. You had me lost for a minute, boo. Absolutely. 10 years this channel was sitting here. And one day I got up and I said, you know what? I'm just going to do it. And if people like me or like my content, they'll come. And I started this channel 4 weeks ago. I think 4 weeks ago. I have what, 20 videos? Something like that. I don't know. Right. Talking about she gonna be gone for 8 weeks. Like the nerve. Thank you, Bama. I hope she hears it too. I'm so tired of people harassing her. I really am. They do. And I don't care. Why? You ain't gotta tell me how old you are or nothing if you don't want to, but why? Let me tell you something. There is a lady that went to law school. Hold on. She either started when she was 82 or she graduated when she was 82. You have an advantage. You want to know why? Because you're going to be a mature student. You're going to listen. You're going to take it seriously and you're going to apply yourself. A lot of kids that go to school after 18, like, they go right after, a lot of them are burnt out and they're done. A lot of them don't know how to handle things. A lot of them haven't had the chance to experience life and the world, and they don't know anything. They're babies, right? So, no, no, that ain't no I'm not you can't use that excuse either. No. Okay, I'm 41, and what that mean? Oh, she going on the ocean, y'all. Well, you just stop in, girl. I hope you have a good time and everything. Okay, see, look. See, we're not I'm not listening to none of this you saying to me. Okay. In fact, every time I do a live and you're here, I am going to keep asking you about it. Now what? What you gonna do now? Just gonna go. Hmm. No, see, we are rallying around you, Fee. Okay. I got 2 kids. The youngest are 7 and 8. Hopefully, my husband does not deploy again anytime soon. I have a 16-year-old. Okay, you can do it. You can do it. Let's see what John's telling us. Fee, I'm 42, going to try to be a correctional officer again. I shouldn't at my age, but I plan on doing it for the state of Texas if I get my pardon. Okay, Fee, we waiting on you to say something. I'm waiting. While I'm waiting, I'm gonna look for another video. What y'all want? Y'all want me to do this yellow shirt day so bad. What do y'all want me to say? I don't even think I have anything to say about it. What y'all want me to say? He showed his ass. What y'all want me to do? Cause listen, I gotta do that interrogation video tomorrow after I cook this chicken for my men that come home tomorrow. Okay. So I gotta do my videos first and then I gotta get in that kitchen. But we up. So if y'all want to do a quick video or y'all just want to have another chit chat, I'm down for it or whatever. Y'all let me know what y'all want to do. Yellow shirt. See, here y'all go. I knew it. Mhm. I see you ain't saying nothing. You ain't saying nothing for you. What you gonna say now? Everybody rooting for you. We all rooting for you, like Tyra Banks said. Mm-mm. Isn't Yellow Shirt Day the same day as the the Oh yeah, girl, it's gonna be nice. He's just in the next city over. He's reserved, so He has to go once a month, but I mean, it's nice to have a little break sometimes. So I'm enjoying my little break, but I will be happy to see him. I mean, he's a good man or whatever. Well, I guess while we're waiting on Fee to tell us, okay, here she go. Let's see what she said. I'm waiting on one thing and then I'll try to make that move. We waiting on you too. I'm rooting for you. I really am. I am. So I guess I'll leave you alone for a few minutes, but all right, I guess I'll go on here and find this video y'all talking about because y'all not gonna let me rest until I do this. Y'all not gonna let me rest. Let me see something. What's all these notifications on here? Oh, here we go. Okay, I don't know if it's true or not. I want to say something. I'm not going to say the person's name, but I have to say this. I understand a lot of y'all are new subscribers, and I really do appreciate y'all. But I said on the last live that I understand that there are other channels that have court records and other things that I don't have, and that's for a reason because um I don't want that to be what this channel is about. And what I mean by that is I don't want this to be just another commentary channel where I just don't want I don't want it to mimic somebody else's channel. And I don't want the information that they have to cloud my judgment and to cloud my opinions. And so I don't mind people finding my channel and commenting. I'm not saying that. There was somebody who subscribed to me today and literally went through every video without watching it, but took it upon themselves to go through all of the comments and criticize what other people had to say. And I'm going to tell you now, for all everybody that's new that have subscribed, and maybe the new subscribers I'll get after I end this live. We don't do that over here. Everybody has a right to an opinion. Everybody has a right to feel what they feel as long all I ask is for everybody to be respectful. I think that was very uh distasteful, if I may, of you to go through every video without even watching the video, but focusing on the comments just to tell everybody that they are wrong for feeling the way that they do. I don't tolerate that. So if you've noticed, and you can go ahead and unsubscribe, I'm not being mean to you, but it is what it is. I blocked you from commenting on my channel. I'm not going to tolerate that at all. If you have information from another channel that you want to share, that's fine. But you're not going to use that to bully anybody over here. You're not going to make anybody feel bad about how they feel about something, period. I'm not gonna talk about it no more, but I just want you to know because you're probably watching the live because I haven't blocked you off of the channel, but you will not be able to comment on my videos anymore. Okay. So I just need you to know that. And I need everybody else who's new or are thinking about subscribing. That is how I feel. This is my channel. You're not gonna bully anybody for feeling anything that they want to feel. All right, we got that out the way. Move on. All right. I think I'm gonna go to Mushmouth Joe, and the reason why is because he edits his videos to perfection. Um, and so it just runs smoothly without a lot of that dead space and the silence that occurred during the trial. So I gotta remember, hush, I gotta remember what day is it? Let me find it, Lord. Now hold on, because how much of this look, if y'all look, okay, how much of this we gonna watch? It's already 11:30. I think this mess is 2 hours. Well, it might not be that long because he cut it down. Let me see where we at. Is it day 7? No. Let me see. Hold on, I'm gonna find it in 1 second. Is it the day after uh Detective Casey testified? Y'all let me know. I can't remember. Let me see. Yeah, we rooting for you. We all rooting for you. Right? Right? See? Okay. You so nuck if you bug, baby. Ready? Oh, they won't do it anymore. They won't ever have privileges again to comment. Now, I was letting it go at first, but then I'm just like, I don't, we're not doing this. No. Mushmouth is the truth. Hmm. And as you guys see, I'm not opposed to anybody's perspective. I'm not. And what do I always say? Just be respectful. Exactly. This is not a group think channel, but it's a way to do it. Like I just felt it was extremely rude to go through, like I said, you wouldn't even give me enough respect to view. You wouldn't even give me enough respect to view the video, right? You want to see what other people are saying and then make them feel bad for saying it? Nah. We're not doing that. Like I said, if you have information to give me, do that, right? But you're not gonna bully anybody. That is the one thing that I will not ever tolerate over here. So I don't know. Maya girl, where you been? In and out. This may be unpopular opinion, but I think he didn't know the parade was live streamed, and that's why he you know what I think? Because somebody asked me about the mask too. I think that he knew that he unalived 6 people and they weren't here to identify him. And so I think that when he took off his mask when he was doing his direct examination and those people basically couldn't identify him the way he thought they could, that is why he said that. Who knows, girl? He didn't know they had all of the evidence that they had. He didn't know, but that's his fault because you should have talked to your attorneys about that, right? He would have known. They had all of the evidence. Remember when they said that they had given him the boxes of discovery, but um they weren't I guess they had to turn over like the DVDs to the jail and then I don't believe that he went to the law library where he could actually view it. I don't know. Who is you? Who is you? Okay. Let me let me see. I think it was the day after Detective Casey. Let me see. Hold on. Oh Lord. Hold on. Uh-oh, he arguing. Hold on. Uh-oh, there go Nicholas Kirby. So it ain't this day. God, what day is it? So that was day what? Hold on, I'll be back in a minute, y'all. I'm just trying to find yellow shirt day. That's all. That's Detective Carpenter. That ain't a yellow shirt. Is this it? Day 12, maybe? He had only wait, here we go, here we go, here we go. Yep, there. I found it. Because this is right after the Brady claim, right? Hold on. Okay, y'all, wait, I think I found it. I think I found it. Excuse me. What y'all talking about? Yep, I agree. Yes, because he just knew that he was gonna go in there and say, "Y'all done broke my shoulder off and my knee," and that was the end of it. He thought the lady was gonna do the investigation, and he thought he was going home. I'm telling y'all. Oh, excuse me. All right, y'all. Here we go. Wait a minute. And I need to use the bathroom and get a snack. So I'm gonna just turn this on and then I'll come back and see what y'all talking about. This is the infamous yellow shirt day that y'all just won't let me rest. Here y'all go.
Have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity. You will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted. I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because that only mutes your audio coming into this courtroom. I confirmed already
Why
that
is my audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
Come on, man. I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights even constitutional rights can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although
Hold on, what y'all talking about? I had to go get a little snack. I'm sorry. Hold on. Mm-hmm. I think I read all of them already. Where I leave all that? Hold on. Okay. Oh, hey, Mika girl. What's up, girl? So didn't. How you doing? I hope you're doing well. What? Ain't that part so funny, child? I was hollering when I first started watching his videos. Oh, oh God. Probably so. Hey, man. I'm about to turn it back on.
a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point. I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin.
Promise this is not a mukbang. I'm sorry for showing, but listen. Listen. Now, I read that if he did choose to testify, it would be more of like a narrative. So he would get up there and he would speak on his own behalf and just provide a play-by-play of what happened, what his defense is to the jury, and then of course he would be cross-examined, but he would have the opportunity to either answer the questions or refuse to answer or whatever, because he was his own attorney. So I really wish he wouldn't have given up his right to testify.
20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by.
Now, he got the Bible in his hand, y'all, but he looking right at the monitor. He hear her. In a few minutes, he about to talk about he couldn't hear good because he ain't had a headphone. The headphones on. This dude, he was literally looking right in the monitor. Y'all see him?
Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you're going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning.
Now, do y'all think, excuse me, do you think that he was trying to get the bailiffs in trouble because you know that they aren't allowed to interact with him? So do you think that him turning around and continuously asking them what she said was a way to find a loophole so he could throw the trial? Which I think.
In the other courtroom, he did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made?
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false record saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my.
So to me, even though Dawn, she set him up, if you think about it, because I think she knew that, I'm sorry, I'm having a little snack. I think she knew that recall wasn't gonna work, right? And so she sent him in there knowing that he wouldn't be able to explain that correctly, first of all. But also, in my mind, the way that I think she set him up because she knows how he has tantrums and meltdowns when he doesn't get his way. This is the last day of trial for him, right? Isn't this the last day? Yeah. And so with Dawn not coming in to support him, this gives everybody an opportunity to see his true colors for real, for real. We ain't talking about nothing from before. This is talking about present day of this video. She didn't do nothing but set her son up the whole way. The whole day. Like, you sent that knowing you didn't have no proof, no paperwork, no nothing. You sent him in there to say something that he probably didn't understand himself. I barely understand what it means when a car is recalled because I never had that issue before. I had a couple people tell me what it was, but she didn't do nothing but set him up. You set him up to show his ass and lose his opportunity to try to sway this jury possibly another way. Crazy.
Oath, again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to?
You know what? I think so too, Fee. You're right. I think that with him being in jail, as it relates to Dawn, it's an opportunity for her probably to not be afraid of him anymore. In her eyes, he's now safe. You know what I mean? Like, he's housed. They're in charge of where he is. She knows he's going to have somewhere to sleep, something to eat every day. I mean, even though it is prison, it takes him off of her hands for a little bit. So you're probably right, girl. You think about Don's anyone setting him up? It's very similar to his own. Do you think there's the consequences of what, girl? I gotta read it again. Hold on. You know it's late, girl. If you think about Dawn setting anyone up, is that what you're trying to say? I think I understand what you're saying. John, don't start now. Hey, dog. Have we missed Welcome to the Club? Wait a minute. I don't think so. I'm about to push play, but I just had to read Fee's comment. Okay, I'm about to turn it back on.
How long have I been unmuted? You just
Sir, do you want to testify in
you
this
just said you
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to?
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want
You
to
can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for me.
answer. I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial, his repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware. So why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying to.
Did you hear me say that?
Questions for, I didn't hear you ask me anything. And
Sir,
I don't understand.
Stop talking and I'll ask it again. Sir.
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
Yeah, I can hear them. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
being
blurting out
disrespectful.
information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will.
She probably would, but I would have really loved if Leslie would have did it. My girl Leslie. Oh, because she was 18 when he met her. You think so? I think so. Because remember, she's not that bright. Okay. And I don't think he would have been triggered by Leslie, but Leslie is no joke either. Okay. Leslie would have brought something up out of him too.
Honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct, whether a criminal defendant. Advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions. And I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll give them back to you during deliberation. Thank you. Be seated.
Y'all, here it comes.
I will have Teresa print off what at least we do have for both parties.
I can't stop laughing. He just knew, okay, let me tell y'all something. Remember how I did that video and I told y'all that even though we know he understands everything, I told y'all and I gave y'all case law that if he kept saying that he didn't understand, that the judge had to make sure he understood or either had to get some type of counsel in there or he had to pay for counsel or whatever needed to be done for him to understand. And he just sat up here for almost a whole hour saying that he didn't understand and trying to give her a hard time because he just knew that was going to throw the trial. He knew that in his mind, she could not move on, without him understanding or without him giving the okay to testify and to not testify. And so she ain't playing no games with him because he's being a child. She's let the jury know we are done. Okay, we're going to have closing arguments tomorrow. So y'all go home and get a good night's rest. I'll see y'all in the morning. And he getting ready to flip out.
I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess. On the record, appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record of, he did a decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right. That's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
Nope.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first.
Did he think that the deputy was his friend, and so now he mad at the deputy because he had to go over there and tell the truth? Did y'all see the way he looked at him when he came back in there?
Last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the clerk of court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being that was an issue raised by Mr. Brooks previously? Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same 107 pages. And then my written copy is on its way.
Access the value, return the value, each document.
Okay.
That's if I'm not muted.
You're not muted.
I also would like to again ask the subject matter jurisdiction to be proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that, the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have a debate about this
Are you
now.
denying
I
me-
have,
are you-
I gotta
are you
mute you
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions.
Uh-oh.
I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions should be
Motion.
written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's
Right.
not proper. That's hearsay.
Mhm.
And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail, they are all irrelevant.
So y'all know what she's talking about, all of the filings. So like all of his ICF forms that he completed in the jail. I think all of the times that he had to write her to pledge to come back to the courtroom. I think that was it. But he, for whatever reason, he wanted that admitted into evidence. And I guess I'm assuming to show that she was biased towards him. I I believe that's all that was in there. But yeah.
Not probative and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply.
Has anybody on any other channels actually reviewed the jury instructions and presented them on their channel? If not, let me know. I can download them from Marquette Law School Library and we can go over them. So y'all let me know.
Put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them. And I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that. And then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
Right, you're unmuted now, but but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you,
Right,
filed.
Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper. You need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence.
It probably was, and he probably had some stuff in there about subject matter jurisdiction, and so on and so forth. Oh, Emily Baker did? Okay. Emily Baker is amazing. Exactly. Because they biased, remember, against him. uh, oh, okay. Yeah, I don't know. I can download it. Hold on. Hey, Bluesy News. I think we went over a little earlier. You probably just got here. No, I I don't even think that he was I don't even think that he was aware of any of that yet. I think that he dismissed his attorneys, one, because he wasn't in control. You can't tell a defense attorney what to do. So it's not like when you have a private attorney and you can, sit down with them and you guys can work out a defense. When you have a public defense attorney, they are in control of everything. So they will collect the evidence. They'll wait on the state to produce whatever evidence that they have, and they have to go based on that and create the best defense possible. You don't go in there and say, well, I don't like that defense strategy, so we're not going to use it. That's not how it works. And so, he wants to be in control and he couldn't control that. Also, I touched on it a little bit earlier. I think that because his NGRI claim would not work because he didn't have the correct mental defect for it to stick. I think that pissed him off even more. And I think that his old defense attorneys told him that they probably did not have a good defense strategy for him. And so, they just had to just sit and just try to, I guess, sway the jury another way. And I just deep down inside, I don't think that he agreed with that. And that was that. But what we're talking about now, I don't think that they told him anything about filings and how something becomes evidence or any of that, because he got rid of them before they even had enough time to explain anything to him. So that's a good observation. But I personally, I don't think that that's what it was. Yep, a tantrum. He's having a tantrum. So that's, I think I remember saying this before. I really want to know, like, when his trauma started in his childhood. And I feel like that's what this is. Like, something happened at a certain time in his life that when things don't work out the way that it does, he goes back to that age. Is showing right now. Right. And so, yeah, so with a plea, of course, he would have to plead guilty, and he's not willing to do that. And he said, y'all got to go. Let me see what time it is. How much longer we gonna go? About another 30 minutes? I think we could do another 30 and 40 minutes, and then we gonna peace out. Okay. Y'all want me to speed this up a little bit? Excuse me. Yes, no. I'm gonna I'm gonna speed it up just a little bit. Hold on a second. I'm gonna put it on 1.5. Let's see.
You deny me the fact, how can you deny me my right to present evidence?
Right?
I
I will
told
mute
you
him
before
once
this.
again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but you acknowledge receipt of the draft of the final jury instructions.
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
see.
documents from the floor and put them in front of him.
And
once
I'm
again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense. How can you tell me when I just say it?
I'm going to read it once again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70.
Hold on. Excuse me. Sorry. Okay, thank you, artist. I will download them and let me see. Tomorrow, I'm gonna do 2 videos for y'all tomorrow. So tomorrow I'm gonna break it up in 2 because interrogations are pretty long. So I'm gonna finish the interrogation and then I'll probably do jury instructions. I'll just download them and take a look at them. Okay, we'll stay into that. Yep, I agree. Okay. So you think his late teens? Um, or I mean, you think something happened when he was younger and it affected him when he became a late teen? I don't know how to do that. I think I have to speed it up really, really fast and then we we won't be able to hear it. Excuse me. Excuse me. Okay, I'm gonna push play. Oh, here we go,
I
y'all.
don't want to do that. What do you got?
He fought with his first box, don't he? Look at him, look at him, look. No, it's the second one.
76, the 76 count. Just want to make.
He gonna
It says New York
fall.
Free Park, so it is in there, but that was one question I had. All right. So state have any requests as it relates to the jury instructions?
This is
Madam Swayze, just one on
ridiculous.
50 of 107. Everything's looking great so far.
Okay.
Oh,
Fair enough. There's
Jesus.
27 pages. I certainly can give the party some time to continue to read through them. Mr. Brooks is requesting to go back to the cell at this point. I'm going to deny that request. He can remain in the other courtroom.
Oh, God. Oh, that is so childlike. So you gonna build this fort, I'm sorry. You gonna build this fort in front of this doggone monitor that you know she's gonna periodically look at. And then you gonna peek around it to make sure that she's looking. That is just like a child. Like a child you told to put in a corner, okay? You told them to stand in the corner and they peeking around to see if you looking to see how upset they are about being in the corner. Oh God. I cannot. Oh God. Yo, let me tell y'all something. I would have paid anything that they asked of me to hear what he was shouting in that courtroom, in that neighboring courtroom. Nobody has been able to amplify it so we can hear it. I wish. Oh my God, I just wish. I mean, his head is bobbing.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling. I'll advise Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me. Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury. Mr. Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated and a loud raised voice, I'd ask that you write it down. I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level.
Hold on. Yep, I agree. Yep. MJ and Mushmouth is hilarious.
Tone of voice and volume level that he is using from the neighboring courtroom. Mr. Brooks, I'll advise you once again, if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
Has reviewed all for the investigation.
Thank you. I know upon my review, I noted a few spots that either in the headings, some information or words that might need to be removed. But why don't you go through and tell me what requests you have, starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107. And when we talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers. So they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And just was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant.
I can see the outline of his arms. I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table? So
Yes, I think that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks.
Oh.
I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you can move the second one, because it can interfere with the microphone as well. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell me to move my mic?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
related to the jury instructions, sir?
yeah, I got requests. It ain't like they're gonna be honored though.
As it relates to the jury instructions, sir, what are
I
your?
heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any?
Now, y'all, excuse me. Do y'all really think that he didn't understand and that's why he got so upset right there? So like that's why I wanted to do a video about jury instructions so we can look at it together and I can try to analyze it. We already talked about how complicated it is to understand the law. If you're not trained in the law, it's just certain things you don't understand. So is there a possibility that he didn't understand like he's already upset. We know that. But I'm saying, do you think the fact that he didn't thoroughly understand what was taking place as far as the jury instructions, do you think that uh infuriated him more because he didn't understand and she couldn't explain it to him? Where are we at with these comments? He is an evil seed. He absolutely is. I don't, but it's okay. You know I ain't gonna get it. So bell jumping, so excuse me. Prior to the incident with his nephew, he was out on probation. But he was given a signature bond and basically with a signature bond, you don't have to pay anything up front. They let you out in hopes that, you won't disappear and you'll come back to the court when you are scheduled to appear. And he didn't. He did that 3 times. So basically, with bail jumping, you're violating your terms of the bail conditions. So the bail conditions were that, you reappear to court at whatever date that they established for him, and he failed to show up. So he was issued a bench warrant, and he did that a couple of times up until this parade incident. So I hope I explained it pretty good. He did. Right. Yep. He was out on bail. He's been out on bail, so that's the thing. Like, if you look back through his criminal record, like it was only 2 times where he was arrested and served jail time. The other times he was just out on signature bonds, which was absurd to me because the majority of his cases were felony cases. And so I don't know how they just felt, okay, we'll just trust that you're gonna come back when he never showed back up to court. Hey, and it's lit. Oh, it is absolutely a control thing with them. Oh, I appreciate you, dog. At all. He never will. You think so? So he understood that we're at the end of the trial, but not understanding what the process of jury selection or just what happens next, or the fact that he forfeit his opportunity to continue his defense. Oh, well, he gonna understand not he gonna understand wrongdoing. Absolutely. Yeah, absolutely. Well, she did give him what she could. So at the beginning of the trial, she gave him what all of us use. It is the federal rules of civil procedure and the federal rules of criminal procedure, which had all of the statutes in there that he could have referred to. And she was very generous with the information that she provided, but he just chose not to look. And also, even in the jail, like I feel like they were very accommodating as far as research, with the law and things like that. He had it at his fingertips. He didn't even have to pay for a subscription to it. You got Westlaw or LexisNexis on there, which will be valuable tools for looking up case law that relates to your specific case. He had access to the law library, which would again provide him with resources to help him break down legal definitions and how they apply to his case. So they all were very accommodating, in my opinion. He just was too, I don't even know the word, to whatever, to take his time to actually look at it and try to understand. Doesn't make sense, but I hope I explained it to you. So yeah, basically, like I said, when they give you a bill and you don't show up to court, and then of course he went and committed another crime. So I think he read and understood what he wanted to understand. He applied what he felt was relevant to him, but his defiance was not trying to understand uh things that were beyond his control, if that makes sense. Mhm. 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 He meant that. He did. Yep. Oh, okay. I'm sorry. It's late. Right. That makes sense. Yeah, he has that big book. And I mean, see, the thing is, like I said, it's a lot of stuff in there. Like, if you're just reading it to read it, you're not gonna understand it. But he had the opportunity to take that with him, I believe, or he could have spent his lunch break looking through it, or whatever he needed to do to look through it to try to find what was relevant to his case. So with a statute book, it's broken down based on criminal offense. So we know this is a murder trial. So he could have flipped right to that section. It's actually 960. It starts at 960 and it goes all the way through. So it talks about bail, it talks about criminal intent, it talks about how to plead, for how what you need to do to get an insanity plea. I mean, it lists every little thing. It tells you all of the elements that must be met in order for you to be charged with a specific crime. So all he needed to do was flip the 960. The statute starts at 960. Go through it. You're charged with intentional homicide. So you need to focus on those specific statutes. Write those down. Go back to your cell. Look up that case law. Figure out which one applies to that. If you don't understand the words in there, you can look at the Black Law Dictionary, which he mentioned during trial, um, or they have another book called Oran Law Dictionary. Hell, you can Google it if you need it to be simplified. They have a website called Quimby that you can use for free to break down different case law for you. So I mean, he just chose not to. You don't understand it, or he didn't understand it. What, the jury instructions? Yeah, they read, and I mean, they're well versed in the law, so, they already know what's up. It's him. He the one need all this extra help that, he's refusing to accept. You know what, dog? I did read something once where they said there was a paralegal, I believe it was, that tried to use AI to do their work and cost the law office um some clients, and then when God, the bar association learned of it, those lawyers got in trouble because a lawyer is supposed to double check everything a paralegal does, and they just ran with it because of the caseload. So I think it's gonna be a problem for everybody. Hey, Rosie. I think he was trying to get contempt of court thinking he can get a mistrial. But that's where he doesn't understand because with contempt of court, that's just a punishment because you're acting up. So that's not good. I'm not fussing at you. I'm just saying he's not even thinking clearly because that's not going to cause a mistrial. Lawyer or not, contempt of court is contempt of court because you're misbehaving. And so she's either just going to add some time to your sentence or assess you a fine or something like that. So that wouldn't cause a mistrial. Almost. Almost. You don't understand jury instructions? So I'm gonna do a video on it, I'm gonna explain it, but basically, each state has their own set of instructions, and then the judge, along with the defense and the prosecution, can go in and add different elements to the jury instruction to fit that case. So in this case, they're just making sure all of the charges are in there, they're worded correctly, um, just different things like that, so they can explain it to the jury so the jury can um, deliberate because you gotta remember a jury is not they don't know anything about the law, they're not there to interpret the law. They have to follow the rules within that instruction packet so that they can deliberate and make a decision. So that's basically all it is. Oh, okay, Sparky, I know. I hope I wasn't coming off like I was being, snarky or whatever. Mhm. 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 I mean, look, law is hard. I understand that, but I feel like if you're a private attorney, it's up to you to decide how many cases you want to take. Also, you decide um what type of cases you want to take. So there's no need in being lazy. Like it's not an easy job. It takes a lot of research. And that's why you have a team and that's why paralegals are a valuable asset to the team because your paralegal will be the one that does a lot of the research, if not all of the research for you. They are the ones that draw up motions. In most states, they're allowed to go to court. They can't represent anybody at court, but they can go to the court to make filings. They can go to the court to listen in on, the case if they need to. They can go to the jail to actually interview clients. They can do a lot of things that take some of the work off of the lawyer's backs or whatever, and then the lawyer will just oversee. So all of the motions and different things that are filed before they're filed, a lawyer would check. And then that gives time for the lawyer to take whatever evidence that the paralegal did to formulate their case or what have you. And also it gives them more time to spend with their clients. So that's just lazy to me. What did he say? That the vehicle was used as a weapon? Is that what you're talking about? So that's a charge across the board. Any state. So, I don't know if you've ever heard like vehicular homicide or vehicular assault. If your intent, so we go back to that mens rea, if your intent is to cause harm, something has to be to harm. So it's either the person that's using their person to cause harm. So you're physically fighting someone and you cause a great amount of harm, or just as you would a knife or a gun to cause harm, you can with a car if that's the intent. Now, if you accidentally hit somebody or run them over, then it wouldn't be a charge, but it just depends on how they prove that criminal intent. Mhm. I think that's what you mean. How did they say that the vehicle was a weapon? Let me know. I'll stay on here a little bit longer, then we gonna peace out. Are you sure? So that's just like, let's say you get into a fight with somebody and you pick up a bottle and you bust them over the head, and then, that will be the weapon. So you can use anything as a weapon. So that's one of the statutes. I can look it up. Not now though, because I'm tired, but directly. So are you talking wait, which charge are we talking about? Are we talking about Erica's charge, or are we talking about during the parade? Oh well. He's an idiot. We don't listen to anything he says. So was that one of his charges? I don't remember seeing that on there. I know they said I gotta pull that back up. Oh, his enhancers? Oh, I don't know anything about that. It's okay. So y'all telling me that Darrell said that the vehicle doesn't apply because he's saying that the vehicle can't be used as a weapon? Is that what y'all saying? And Debbie, what was your question? You didn't understand how the vehicle would be a weapon? So originally he had 83 charges, but a lot of them were dismissed because they were extra charges. You can't give multiple charges uh for one count, if that makes sense. Or I may have it backwards. But so for instance, he got 6 counts of intentional homicide, and then they tried to add on, oh God, I gotta, what, I'll do that in the video. I'll read all 86, 83 charges, but some of them, six, let me see. Hold on, let me do my math correctly, y'all. It's late. I'm tired. 7, 8. What was that? 6. So 6 charges were dropped that were like duplicate. So in total, it was 76 charges, right? Wasn't it 76 charges? 77 got dropped. 6 were intentional homicide. Some of them were hit and run with a deadly weapon or something like that. I have to, here, y'all gonna make me pull it up. Just give me a second. Let what play, crowd participant? What? Because we tired. Oh, okay. So I'll have to let me write that down so I can look at it, and then maybe I can do a video on it. Where is my handy dandy notebook? Hold on a second. I'm gonna write it down so I don't forget. Maybe what I'll do is the video that I have coming out tomorrow, I'll explain it in the beginning. Um, because I actually read it earlier today. I just can't think straight right now. Okay, I remember. Oh, school opera said that. 76, 71 reckless danger. Okay. Okay, Bama, we can ready to go. I appreciate you for hanging in there with us. I'm sorry, crowd participants. You came in here late and we ready. We ready to go. Okay. Any last words, thoughts? Okay. I'm gonna look into it. I'll look at it tomorrow and I'll put it in the beginning of one of the videos because I'm gonna do two. I'm gonna try to finish up that interrogation tomorrow. But it'll be two separate videos. I do too. Y'all are amazing. All right, y'all. So we're gonna peace out. As always, I appreciate all of y'all. Thank you for coming to my live and participating with me with this crazy defense strategies, those crazy defense strategies we tried to come up with. Debbie, you're all good. This is a learning channel. And so I will see y'all tomorrow with these two videos that I come out with. Y'all be easy, okay? Peace.